Greetings and welcome to Law of Evidence, the nature of documentary evidence from American Jurisprudence. Before we get started, let me make sure sound settings are correct and we'll get right down to the topic. There we go, that should be better. Greetings, let's get started. So we're going to be going over documentary evidence. This is in Part G. And Chapter 1 of that is in general, starting with Section 1023, Nature of Documentary Evidence. Before we go any further, just remind everyone this broadcast is strictly for the entertainment educational purposes of this YouTube channel only, not to be used misconstrued for any other purposes, processes, or otherwise for your private, personal, lawful, legal, financial, tax, or otherwise. So please don't do this at home. That being said, let's continue. Documentary evidence is generally defined as evidence in the form of a writing or writings. A document may be defined as any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of such means intended to be used for the purpose of recording that matter. So, again, this is from a 1998 edition of American Jurisprudence. So, that being said, consider all the differences in technology of documenting evidence that have come about since this writing. That being said, remember it's as any matter expressed or described. Comment: since the essence of documentary evidence is the recording of statements or information, it would appear that a sound recording of a statement may also be deemed documentary evidence. The federal and uniform rules of evidence refer to writings and recordings, which consist of letters, words, sounds, or numbers, or their equivalent, set down by, among other things, handwriting, typing, printing, or mechanical or electronic recording, which would be the mainstay of the information we have recorded today. And our footnotes here: a writing or document, in addition to handwritten or printed or typewritten instruments, which first come to mind, should include inscribed chattels, photographic or other mechanical reproductions, and sound recordings, even though in the case of sound recordings, the inscribed marks may not be visible to the eye and may be read only with the use of mechanical devices. Now, of course, we have digital devices too. Documentary evidence includes every tangible object capable of making a truthful statement. Whew, that's a good one there. Every tangible object capable of making a truthful statement. And of course, we're always going to have references to our uniform rules of evidence. And this is Rule 1001. All right, we're on to Section 1024, Use and Restrictions on Use. Let's jump over here to the chat and give it a quick refresh. Make sure everyone here. Greetings, Bill Thomas, and audit them, and everybody else. Please make sure you hit the like to make sure that this gets out on the algorithm, as it seems notifications may have been thin tonight. To be admissible, documentary evidence like oral testimony must be relevant and competent. To the extent that a document operates to establish a fact, it may be admitted as direct proof of that fact. So, the document operates to establish the fact, and it may be admitted as direct proof of that fact. We need to prove facts for them to be admitted as evidence, and the document operates to establish that direct proof. properly admitted document is generally regarded as only prima facie evidence of a fact, which may be disproved by other evidence. So we could say that the document is generally regarded as only prima facie evidence. So it may be disproved by other evidence. Keyword may. Recitals in a document may, however, be binding on a party as admissions or declarations. So the recitals in the document may be binding. So that goes beyond prima facie there. So we have two different footnotes here, 67 and 68, referring to those instances. Oh, it's a good long section here. So we have as to admissions and declarations generally. We'll see section 754, which was earlier. Okay, so that's our supplement for this. Okay, good. So that's why it's so long. Documentary evidence, like oral testimony, must be relevant to be admissible. Documentary evidence is also subject to general exclusionary rules, such as the rule against hearsay, the best evidence rule, and the parole evidence rule. Evidentiary rules concerning privileged communications may bar disclosure of documents relating to such communications, so privileged information is not going to be used as evidence. Where, however, such a document comes into the hands of a third person who is neither a member of the protected relation nor an agent or representative of one who is, the document is no longer privileged and admissible in evidence to the same extent as any other writing. Observation. In many instances, evidence codes specifically exempt certain documents from the application of exclusionary rules. Thus, Rule 803 of the Uniform Rules of Evidence and the Federal Rules of Evidence exempts from the hearsay rule numerous classes of documents such as records of vital statistics, family records, and records of regularly conducted business activity, while best evidence objections to the introduction of a copy of a document made by a process which accurately reproduces the original are largely obviated by Rule 1003. If a person is not legally competent to testify, the law will not permit him or her to make a memorandum of a fact and have it introduced as evidence of that fact. So if they're not legally competent to testify, they cannot make a memorandum or a document of that fact to be introduced as evidence of that fact. Let's look at these footnotes here where we left off before we get to the supplement. And against hearsay rule, that's best evidence rule, farm stores, hey, remember them? Let's see here, parole evidence rule. So these are just references, compensated. All right, so let's get to our supplement. Now this is going to be our 1998 supplement, so even this supplement is outdated. This is use and restrictions on use. Case authorities. Assuming rule applies to discoverability as well as admissibility. Documents provided to settlement committee in prison overcrowding case were not protected, since plaintiffs did not seek documents to prove liability for or invalidity of claim or its amount, but to rebut defendants' claims of changed circumstances and thereby oppose petition to modify settled agreement. So, oh boy, settlement committee and prison overcrowding case were not protected. They did not seek documents to prove liability. Okay, only to rebut claims of changed circumstances. Even if admission of other money orders sent by defendant from prison were improperly admitted in mail fraud trial for operating money order scam from prison, error was harmless since defendant had already confessed his involvement in scam and evidence against him was overwhelming. Jeez. Evidence of plaintiff president's falsified documents, which he sent to person in support of finder's fee for orders placed with plaintiff by defendant, although critical of president's character, were substantive evidence relating to disputed issues of relationship between plaintiff and defendant, custom and practice, damages, and plaintiff's reputation in plaintiff's action alleging that the defendant misappropriated its trade secrets, specifically advertising insert it designed for defendant. Specifically advertising insert it designed for defendant. Okay, so they leave a lot of articles out for the brevity of these citations, so they could be difficult to read. I'll try to scan through, see if there's any relevant ones. This one looks good. Section 1983. Action by a diagnosed paranoid schizophrenic who claimed that police officers used excessive force in subduing him while he advanced towards them with hatchet. District Court did not abuse its discretion in excluding certified documents showing number of involuntary commitment petitions that had been filed in county court order over a 3-year period, since documents did not indicate in which, if any, police had played a role and thus did not make fact of consequence more or less probable. Wow. Wow. So I guess that's interesting there. So it's a Section 1983 action from this diagnosed paranoid schizophrenic that claimed the police officers used excessive force. And it seems like they were trying to use some petitions that had been filed by other parties in the county court over a 3-year period. And they weren't able to because the documents didn't indicate in which, if any, police had played a role, and thus did not make fact of consequence more or less probable. So being that, I guess, the incident with a hatchet had nothing to do with police, then it really didn't matter. Cocaine distribution defendant manifested adoption of paper found in his pocket upon arrest. It's a cocaine distribution defendant. Nice euphemism. Manifested adoption of paper found in his pocket upon arrest. Hence, paper containing 3 columns and letters, which were consistent with some of the prices and quantities of cocaine defendant negotiated with agent, was admissible. So, documentary evidence. District Court, in age discrimination case, did not err in excluding summary of documents purportedly showing that older employees were placed at bottom of ranking lists and younger ones at top, where party offering summary was unable to explain meaning of items contained in summary. So they did not err in excluding summary of documents. Okay, because they couldn't explain. They had that plausible deniability. I don't know why they're organized oldest at the bottom. Just coincidence. Computer software firms shall be permitted to introduce documents into evidence, subject to requirement that all prejudicial titles be redacted. Where competitor provided documents containing revenue and related statistics for certain types of software during settlement negotiations occurring after it had already lost on liability issue by default, and titles on some documents could be construed as admission that it had copied firm software, because titles which could be construed prejudicially as admission of liability are protected under Federal Rule of Evidence 408. But tabular evidence in documents was otherwise discoverable. Tabular evidence. Here's a case. In prosecution for marijuana importation conspiracy, court properly admitted deposit slips showing substantial deposits in single account in Panamanian Bank, and application form to obtain checks from that bank, where documents were seized on vessel on which defendants and marijuana were apprehended. Deposit dates preceding beginning of vessel's voyage, deposit slips were signed by defendants. Or typical bank markings were kept in circumstances where a person who has access to account would have kept important documents concerning account, and admission was consistent with general requirement to provide speedy, inexpensive, and fair trial designed to reach truth. Yikes. 94. United States versus Munoz. Arresting officers. One paragraph synopsis report of information received from a number of undifferentiated sources which contained termed refused medical aid attributed to victim was not Rosario. Material as to one late witness where 1. That witness was not quoted or referred to as source of information report, and 2. Although officer who wrote report testified at trial, neither hearsay information nor exchange concerning medical aid related to subject matter of his testimony. Yikes. Monthly billing statements of law firm were properly admitted in evidence where there was extensive testimony by law firm as to how statements were compiled and reviewed for accuracy, and no irregularity as to time and task of record keeping or compilation of billing statements was evidenced, either on direct or cross-examination. All right. And I think we looked through these footnotes here, so it takes us on to the next section. Before we do that, let's jump over to the chat and catch up with everyone. Yes, please hit the like and make sure. There we go. Everyone's getting the word out. Let me refresh this chat. It seems like it's holding back. All right. Yep, there we go. Let's continue. Thin crowd tonight. I guess so on a Sunday, and it is a little bit earlier than usual. Well, it's a very short section. Section 1025, effect of admission by opposing party as to contents of or facts sought to be proved by document. In some cases, parties have been permitted to introduce documentary evidence, notwithstanding admissions by opposing parties as to the contents of the documents or as to the facts sought to be proved thereby. In other cases, however, it has been held that a document could not be introduced in evidence where all that it tended to prove had been admitted by the opposing party. In such cases, the document offered in evidence may be rejected on the grounds that it is immaterial. Ooh. It's an interesting one there. Could not be introduced in evidence where all that it tended to prove had been admitted by the opposing party. So that's the effective admission by opposing party. That means that the document will be rejected on the grounds that it is immaterial. And this works both ways. So if there's an admission as to the facts that the document tended to prove, then it would be considered immaterial and may be rejected its admission into evidence. Section 1026, right of party introducing document to impeach or explain it. 1. Introducing documentary proof bearing upon an issue generally is bound by its recitals in that respect. So, let's see this again. 1. Introducing documentary proof bearing upon an issue generally. Okay, let's read it. 1. Introducing documentary proof bearing upon an issue generally is bound by its recitals in that respect, the issue. He or she is not allowed to impeach or contradict it, or to accept part which is in his favor and repudiate another part which is opposed to his claim or defense. No picking and choosing and cherry picking from documentary evidence, However, this rule does not apply to conclude an issue where the documentary evidence is not offered on that issue. Thus, a party is not bound by the recitals of a document which he introduces for the purposes of impeaching it on the ground of fraud. Wow. Okay, so if you're introducing a document that the purpose of it is because it might be fraudulent, then you're not bound by the recitals on the document. So if the whole point of admitting it is to impeach it, so you're not bound by the recitals on it because it could be fraudulent. A party may also introduce documentary evidence prepared by his adversary without being bound by it. And a party who introduces a document in evidence is not precluded from impeaching it by evidence which goes to its invalidity or which tends to show that it has not in law the effect it purports to have. It's not precluded from impeaching it by evidence which goes to its invalidity. So you can introduce a document and then introduce evidence that would go towards its invalidity that shows it has not the effect in law it purports to have. Nice. So this is a good one. Right of party introducing document to impeach or explain it. Observation. Notwithstanding the general rule against impeachment of one's own witness, a party may prove the truth of particular facts in contradiction of the testimony of his or her witness. By analogy to this rule, a party introducing documentary evidence may prove that the actual facts are other than is stated therein. Let's see what those cases are. 90, 91 should be interesting. Okay, this refers to witnesses in AmJur, and okay. All right, so we're on to recitals as evidence of facts. Cook. Bill Thomas says, sometimes I get confused if admissions refers to items admitted into evidence and facts admitted by the other party stipulations. Well, to admissions is to go, it would be the same thing to admit, either way, to bring it into evidence. To admit is to bring in, right? I guess we could go into a deeper dive into the Black's Law, but the general etymology would be to, I guess, really more to send, right? But to, yeah, I guess that would be it towards sending into evidence. We could take a quick look into Black since you mentioned it, so let's do that. All right, and since it's in the A's, it should be pretty quick to get to. Let me clear this off here. Wow, I went past it, huh? All right. You can't have confusion when it comes to words because part of the goal here is to leave no word behind for whatever context we're using here, terminology included, which all of this is terminology here. All right, admit. Does it come after the ADs? No, okay. There we go. Admissions, we're almost there. Lots of admits. We're just going to try and keep to the root and not get lost in the weeds here. All right, I missed it. Well, we have admissibility, admission, any statement or assertion made by a party to a case and offered against that party, the acknowledgement that facts are true. Admissibility can best be thought of as a concept consisting of two quite different aspects: disclosure to the trier of fact and express or implied permission to use as evidence. Disclosure and permission. So admissibility is the quality or state of being allowed to be entered into evidence in a hearing, trial, or other official proceeding. So this comes into I think, the proper terminology for us in this context. If we think of admissibility as a question of disclosure or non-disclosure, it is usually easy to say whether or not it is an item of evidence that has been admitted. When we consider the question of permissible use, the concept seems much more complex. In the first place, evidence may be admissible for one purpose, but not for another. In the second place, that is the permission, right? Questions of permissible use of evidence do not arise only at the time of disclosure to the trier of fact. The court may have to consider admissibility in deciding whether to give the jury a limiting instruction, as we saw before when it comes to presumptions. There was mandatory and permissible presumptions. Whether or not an opponent's rebuttal evidence is relevant, there's your admissibility again, and whether or not counsel can argue to the jury that the evidence proves a particular point, which we get to the permissiveness, I guess. Interesting there. What is this one here? Okay, yeah, so this is a good insight here. Best be thought of as a concept consisting of two quite different aspects: disclosure and permission. Right? So, for one purpose, but not for another. Interesting. So, that's pretty good there. And then we have admittance. We don't have just the verb there. So, all right. I guess maybe we have quasi-admission, an act or utterance, usually extrajudicial, that creates an inconsistency with discredits to a greater or lesser degree a present claim or other evidence of the person creating the inconsistency. Quasi. It's also acceptance of a lawyer by the established licensing authority, such as a state bar association, as a member of the practicing bar, usually after the lawyer passes a bar examination, supplies adequate character references, admission to the bar. The entry of a lawyer on the rolls of an integrated bar, usually after the fulfillment of two prerequisites: graduating from law school and passing a state bar examination. Thought that came out of quasi-admission. And that's odd. 2. Oh, okay, that comes from admission number 2. Wow, all the way down here. So all these are part of the definition 1 of admission. Any statement made to a party. Wow. And then 3. Cuts down to patents. I'm not interested in that on this one here. And we get to admittance. Admittance, the act of entering a building. Okay, permission to enter. All right, so now we're off topic. We digress far enough. Thank you for those of you that stuck in for that. Let's get back to the topic. Evidence, Bill Thomas says, evidence could be admitted that either admits or denies a fact. Indeed. The ambiguity that confuses me was addressed by that definition. Thank you. I'm glad you got the clarification. That's what we're here for. So let's get back to the topic here and continue with that insight. The recitals of an instrument introduced in evidence may be considered as evidence against the parties to the instrument. So as we were saying before, as evidence against, and generally against the parties only. The recitals of an instrument are not ordinarily admissible against third persons as proof of the facts recited, being as to them res inter alios acto. Gosh. All right, my Latin tongue just got twisted. We're going to have to look this one up since we got blacks at the handy. Res inter. I think I know what this means, but I'm not going to venture. That's R. Legal advice exception. I love some of the things this lands on here. Okay, almost there, and unconstitutional. Okay. P, come on. Quadere, demonstrate it. All right. Almost there. Res. I'm sure it's going to have us look somewhere else, but we got to start somewhere. Here's the going. Replevin, an action for the repossession of personal property, wrongfully taken or detained by the defendant, whereby plaintiff gives security for and holds the property until the court decides who owns it. Writ obtained from a court authorizing the retake of personal property wrongfully taken or detained, also termed in sense 2, writ of replevin. The action of replevin lies where specific personal property has been wrongfully taken and is wrongfully detained to recover possession of the property, together with damages for its detention. To support the action, it is necessary A, that the property shall be personal, B, that the plaintiff, at the time of the suit, shall be entitled to the immediate possession, C, that at common law, the defendant shall have wrongfully taken the property, replevin in the crepit. But by statute in most states, the action will now also lie where the property is wrongfully detained, though it was lawfully obtained in the first instance, replevin in the detenent. D, that the property shall be wrongfully detained by the defendant at the time of the suit. In rare cases, the plaintiff might seek equitable relief to secure return of a chattel, like paper chattel. More commonly, the claim for recovery of the chattel was pursued at common law under forms of action such as detenue or replevin. American statutes or court rules track the common law generally, referring to the recovery variously as replevin, detenue, claim and delivery, or sequestration. The statute usually allowed the plaintiff to recover the disputed chattel before trial, though this is now subject to constitutional limits which have led to procedural revisions in many of the statutes. There's personal replevin at common law, an action to replevy a person out of prison. Wow. Or have another's custody, largely superseded by writ of habeas corpus as means of investigating the legality. All right, we've definitely gone too far. Let's get back to res. Geez, what was it again? Inter alios acta. All right. Go res. Uh-oh. Oh, it's going to go like that, huh? All right. So we get to the I's then. All right, okay. Inter alia, here it is. Res inter alios acta. Res inter alios acta. A thing done between others. In contracts, Here's evidence number 2. The rule prohibiting the admission of collateral facts into evidence. And in contracts, it's the common law doctrine holding that a contract cannot unfavorably affect the rights of a person who is not a party to the contract. Wow. Wow. Now that's interesting too. Res inter alios acta. So again, in this, it's prohibiting the admission of collateral facts into evidence for our purposes. And let's get back to the book. So the recitals of an instrument introduced in evidence may be considered as evidence against the parties to the instrument and generally against the parties only. The recitals of an instrument are not ordinarily admissible against third persons as proof of the facts recited, being as to them res inter alios acta, collateral facts. The recitals of a deed other than an ancient deed are not competent evidence of the fact recited as against a stranger to the instrument, nor are they binding upon him. Well, that's interesting there. Ancient, 96. That comes from section 1249. And that's in here. 1249. Take a quick look there. Not too far from here. What the heck are they talking about? Ancient. Ancient deeds. What could that be? Deeds referred to adjacent. Would it say adjacent? All right. Recitals as evidence is what they're referring to here. A deed offered as evidence of the truth of the matters recited, acknowledged, or declared in it is admissible only against parties and privies, under general principles governing admissions of parties and their privies. At common law, recitals in a deed other than an ancient deed, 85, 1253, they're going to send us all over. Let's go to 1253 here. We're going to find what these ancient deeds are here. Recitals as evidence. Although recitals contain a deed generally not against strangers, evidence of the facts recited when the deed offered in evidence is an ancient deed, its recitals at common law competent evidence of the facts recited, even against strangers to the title, when accompanied by possession under the deed or other corroborating circumstances. Under the exception, recitals of pedigree and ancient deeds are admissible on the theory that, if untrue, they would long since have been disproved, and the time and possession have raised the presumption of this truth, provided there is some proof, even though slight, of the relationship of the declarant with a family. Comment: the rule permitting admission into evidence of recitals and ancient deeds has been regarded as an application to deeds of the general common law exception to the hearsay rule pertaining to ancient documents. Okay, wow. Ancient deed may be introduced as evidence. Wow, so this is interesting here with the bounds and meets and bounds here. All right. Digressed too many times here. Let's get back to where we were. Oh. We're somewhere around here. No, we're not there yet. Sorry about that. We'll edit this part out. Here we go. Recitals of evidence as facts. I think it's where we left off here, right? Yes, indeed. So the recitals of a deed other than an ancient deed are not competent evidence. Okay, so the ancient deeds, your recital of the ancient deed can be admitted as evidence and is an exception to the hearsay rule. Okay, otherwise, recitals of ancient deeds, we did that. All right, that takes us to the end of this section. Now we're on to Chapter 2 here with the introduction of part of writing, which will be for the next episode. So this one should be very interesting here, the introduction of part of writing. So this gets more into the written documentary evidence. And as the maxim goes, the spoken word flies, yet the written letter remains. And with that, I would like to thank everyone for coming here and participating with this presentation tonight. Let's jump over here to the chat one last time and make sure we're up to date with any other questions, comments, anything else. It looks like we addressed everything we needed to here. Please make sure you hit the like on your way out, and we'll be sure to carry on the law of evidence next time. We'll be continuing on with documentary evidence and the nature of it and the various aspects. We'll also be getting into parts with video and audio recording, where as we look at these principles from back in 1998 to see how they've evolved to the technology of today, yet the rule of law still applies. And remember, as we look more to our roots of the common law, that it brings us to a better insight of how it applies regardless of the changes of technology, as the founders intended the law to work for us here with our unique form of American jurisprudence. All right, with that said, it takes us to the last part of our presentation here, where we're going to go over, get over here to these, there we go, to the 54 Stat 178 Joint Resolution. Actually, this is statute at large, enacted by both houses of Congress, signed by the President, authorizing the President of the United States of America to proclaim, "I am an American, Citizenship Day, for the recognition, observance, and commemoration of American citizenship." Remember now, this is enacted law, has not been repealed. It is still law of the land as a statute at large. Whereas some 2 million young men and women in the United States each year reach the age of 21 years, and where it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. Now, clearly, the sovereign citizens of our nations are the American citizens. Clearly, it says it right here, as far as I can tell. That makes this terminology here. This is no longer an oxymoron or a set of words. This becomes terminology synonymous with American citizenship. And it is also desirable that these citizens are prepared for the responsibilities that the self-governing republic demands and impressed with the significance of their status having reached the age of majority of 21 years. Therefore, be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled, that the third Sunday in May each year be and hereby is set aside as Citizenship Day, and that the President of the United States is hereby authorized and requested to issue annually a proclamation setting aside that day as a public occasion for the recognition of all who, by coming of age or naturalization, have attained the status of citizenship. And the day shall be designated as I Am an American Day. That the civil and educational authorities of states, counties, cities, and towns be, and they are hereby urged to make plans for the proper observance of this day and for the full instruction of future citizens in their responsibilities and opportunities. Now they're talking about the future citizens, probably about American citizens, because then they later mention the opportunities as citizens of the United States, citizens of the individual states, citizens of localities in which they reside. So in different capacities that we may have to function, since it is a self-governing republic. That as sovereign American citizens of the nation, right, that there is a significance to that status, and there are responsibilities associated with it to preserve a self-governing republic. Nothing herein shall be construed as changing or attempting to change the time or mode of any of the many altogether commendable observances of similar nature now being held from time to time, or periodically. But, to the contrary, such practices are hereby praised and encouraged. Section 2. Either at the time of the rendition of the decree of naturalization or at other time as the judge may fix, the judge, or someone designated by him, shall address the newly naturalized citizen upon the form of genius of our government and the privileges and responsibilities of citizenship. The genius of our self-governing republic is what this means here, and the responsibilities of the sovereign citizens of the nation, it being the intent and purpose of this section to enlist the aid of the judiciary in cooperation with civil and educational authorities and patriotic organizations in a continuous effort to dignify and emphasize the significance of citizenship. And that refers to the sovereign citizens of our nation, approved May 3rd, 1940 by joint resolution of Congress. But don't believe me, you can look this up. This is authenticated from the U.S. government information, the GPO. You could go look it up yourself to see. But this is indeed enacted into law as a statute at large, and it has yet to be repealed. I think they've changed the date, is about it. But this is the law, and that sets the terminology for some of these words you see here. And you can clearly see the way that there's nothing ambiguous in the way this is written as it is passed by joint resolution of both houses. This has been hashed out to remove all ambiguity before it could become public law, as they say here, and statute at large. So this is the law of the land. Just to let you all know, regardless of how other people try to misconstrue or mislabel, this is the way it stands today. And that's what we follow here on this great land. And with that, I would there it is. Power inherent in the people. You must have felt it ringing in your ears as I said these words here. Indeed. Well, salute to you, having you come out here, and I appreciate you and everything you've been doing out here, keeping the people active. We all need to be doing it. Indeed, let's go. All right, with that, everyone, I want to thank you once again, and I hope to see you all on the next one. Peace out.